Peels not fit to eat or not normally eaten, for example, watermelon rind, banana peels, may be discarded as usual. But those that are edible, including orange peels or peels and pits that have a fruit still stuck on them, must be discarded in the special Shemitah pail. Shells from nuts may be discarded as usual. And Shemitah year food that is fit for human consumption should not be given to animals, as this degrades the food's inherent kedusha. If Shemitah food is given to animals, it must be discarded in a special way. Shemitah produce should not be used for medicinal purposes. And it says, homeopathists, please take note. Shemitah products should not be used for arts and crafts or for cleaning purposes. For example, using lemon juice to remove stains. This also demeans the kedusha. Shemitah wine or grape juice used for kiddush or havdalah should preferably not be poured to the overflow. If a significant amount does overflow, one should collect the overflow in a plate and drink it. Those with the custom of putting out another candle of wine should not do so in Shemitah wine. Shemitah olive oil should not be used for Hanukkah candles. One may serve Shemitah products to a non-Jewish guest in one's home. Shemitah products should not be taken out of Eretz Israel. One may take Shemitah produce with him as food for the journey if he is traveling abroad. Next year, this will be an issue regarding the Arba Minim. Many poskim do permit sending Arba Minim to those living abroad if they are particular to perform the mitzvah of lulav with Israeli Arba Minim. And lastly, when giving Shemitah food to a child, parents should try, if possible, to give only as much as will be eaten so as not to waste the rest. Good idea in any year. Okay.
Yeah, good point. Good idea in a year.
Okay. All right. So listen, guys, I need, I'm going to go as fast as I can, but it's already 13 minutes in. I don't know if I can do it in 20 something minutes, but I'll do my best. Otherwise, I might need another 10 minutes, but I'm not trying to stretch. You know what I mean? Generally, I need 40 minutes. I need an hour, but I'm prepared to do it at 40. I'm going to even try and squeeze it less. I'm going to do my best I can. But we just need to finish this concept, because if you looked at the last two shirim that are up, it was 52 A2 and then A3. We generally do 3 or 4 amuds. We've done 1 amud a day, which means we're not really covering any ground. So I want to just try and see if I can fly through a little bit of content and then give you the details afterwards. It's easier than interpreting each line for you. Maybe I can just do that as a ballad flow. Okay? So listen, I'm just going to do a minute or two of Chazorah. So having clarified the meaning of the Mishnah's words, the Gemara proceeds to analyze its ruling. The master said if the animal fell forward because of the sound of the digging, the owner of the pit is liable. But why is he liable? Let us say that the one digging inside the pit caused the animal to fall in the pit by startling it. So obviously this has brought a question. What was the question? Is that, look, if I'm digging the pit and the noise of me digging startles the animal that it falls forward, what does it have to do with the owner of the pit? Surely the one digging is the one that startled the animal and therefore should be liable. Okay? So the digger himself, we learned, isn't liable. Why is he not liable, Kevin?
Why isn't he liable? If no, I don't know.
You don't want to take a guess?
In what specific? In generally, or is this a specific?
No, in this particular situation, he was digging. He made a sound. It startled the animal. The animal fell in the pit forward, which means you're generally liable. Why is the digger not liable?
No, I can't. Is it because of the The intellect of the animal, is it, no, we discussed that. Why is he not liable?
You want to give an answer?
Arthur?
So give me the one that
Can't hear you, mate. We're trying to hear you.
what's that thing where? Let me try this. Turn off the headphones for the moment. Give me a second.
Okay.
Okay, you can hear me now, right?
Yeah, perfect. Yeah.
It's because the digger's not responsible because firstly he's not the owner of the hole, so he's like the it's kind of like blaming the fireman for the fire.
Okay, can I just ask you something on that point?
It's not the first thing. He's a secondary guy. Though he dug the hole, he doesn't own the hole. He's just working for the person.
No. But there is a concept.
Yeah.
There's a problem because there's the concept called Ein Shaliach Lidbar Avera, which means there can be no agency to commit an act of transgression, which means even if you don't own the pit, but I have hired you to dig the pit, you can't turn around and say, I hired you. If I hire you as a hitman, you're legally responsible for that direct murder, even if I'm hiring you, even if I don't own the pit, but I'm hired to create a hazard. There can be no mitigation of transgression through agency.
So let me finish the answer because I know the answer.
Yeah. Just hang on, Gav. Hang on a second. I just want Arthur to get a little bit clear. I know you know the answer. I just want Arthur to understand this particular point before we proceed. I hope you don't mind. Just give me a sec.
I know that's what you raised is very good.
I don't know. I'm seeing his roof.
Yeah, I'm just gonna go.
Oh, no, that's fine. Do you see why it's not a valid argument?
Yeah, I do see why it's a valid argument. So I'm taking my train off. There's just something I was listening to. Maybe I'm just exhausted and confused at the moment.
No, I'm here to clear it up. So
5 days.
if you the concept Ein Shaliach Lidbar Avera means there's no agency to commit an act of transgression. Meaning, if I don't own the hole, but you hire me in the public domain to create a hazard, and I know it's against the law holds me liable as the person that's doing the act.
Okay. But it's not liable in Shemaim, or I mean, I remember something. I'm just
okay. No. Listen, that's a good point. The person that hires the hitman is responsible in Shemayim because that's close. But on the earthly court, they can't convict the mafia boss because the mafia boss says in court, I told them to take care of the problem. I mean, what I meant was beat him up, deter him. I didn't say kill him. He interpreted it as killing. I told him to make the problem disappear, meaning knock his teeth out. I never gave an order to kill him. So they can't directly, in the court of law, convict anybody other than the assassin if it's hearsay and there's no recorded evidence by FBI tapes, because it's his word against his word. It's only the person that was caught doing the transgression that can't say he acted on behalf of somebody else. He's held legally liable in a court of law. If it's a civil case, he gets prosecuted for the financial damage. And if it's a capital case, he gets the death penalty. In Shemayim, Hashem holds both accountable because Hashem really knows the conversation. Am I making sense to you? So by that virtue, the digger would be liable. The point that you're trying to make is a slightly separate, subtle point that the Gemara brings. And what that point of it is, it has to be a case where the person that dug the pit never made it of lethal capacity within his own amount of digging. So we say, for example, if somebody dug a pit, just let me know that you can hear me, even if you're not on the screen? That's all I want to know, Art. Can you hear me? Mate? Gav, just give me a second, but don't worry, I'll let you answer. I've got no problem with that. I just want to clear this up with Art a second.
You give me my answer over. It's perfect.
I think I may have an idea, but Gavin must go first.
Okay, but can Arthur hear us? That's what I want to know, even if he can't see us.
You must acknowledge. Arthur, switch off your mic and just give us a thumbs up that you can hear.
Or say something.
He's on his bike. That's probably why. Maybe he's on pedaling. That's why he can't touch his phone.
Right. I am finding this sort of share a little bit challenging, to be honest, from a communications perspective. So, all right. So I'll say it over, and if Arthur can hear, hopefully he can. And if he can't, okay. All right. So listen, Kevin, what I'm saying is this. I, as the owner of the pit, dug the initial hazard. Okay. I made it 10 tefachim deep, which is a lethal pit.
No.
The digger might have decided to excavate on my payment orders slightly higher to 11 tefachim, but that doesn't mean he made it from a non-lethal pit of 9 to 10. Otherwise, he'd be culpable. It doesn't mean that he made it from 10 to 20, which means co-liability, okay, as the digger of the pit. That's also something to bear in mind. He didn't contribute to digging the 10th with me, to make him co-contributor. None of the things he did made him liable from the amount that he dug. That's also something that you could say. Okay, that's in conjunction with the fact that he would be liable as an agent, and he can't get out of liability that way. Another point to bring up, Kevin, and this is very important, is that the one thing that you missed, which I know Gavin knows because he did the Chazorah, is that the digger is not liable in this case, the Mishnah says, because he merely created a sound, and that sound frightened the animal. He did not push the animal in the pit. So it's known as grama, indirect damage. Had he pushed the animal in the pit, he would, according to the rabbinical opinion, be totally liable as the primary cause of damage. According to Rav Nassan, he is a co-conspirator in the damaged cause, because the pit is where you found the dead animal, and if there was no pit, then there'd be no death, because how hard are you pushing the person? Okay? The ox, how hard are you pushing the ox? So the pit owner is responsible, but had the person not pushed the animal in to the pit, there would be no liability on regards to that person. So the digger, by the sound, created the animal to be startled, and the animal fell in. We don't make the digger liable for groma, indirect damage, in any way. So therefore, the owner of the pit is liable. Whose opinion is this according to? This is the opinion of Rabbi Nassan, because according to the rabbis, the digger would have been liable had he directly pushed the animal in. But since he did an act of grama, indirect damage by frightening the animal, and the animal fell in of its own volition, even though he caused the sound, it is indirect, and therefore we cannot make him liable. So the owner of the dead animal does not get reimbursed by the digger. And he doesn't get reimbursed by the owner of the pit according to the rabbis, because they don't see a secondary conspirator. This conspirator is the one word, a secondary partner in causing the animal's death. They say, well, who caused it? There's a primary damager and a secondary damager. The primary one would be the digger of the pit. Since he didn't push the animal in, or his digging caused it, but the sound caused the animal to fall forward, we cannot collect from the digger. And the owner of the pit is not liable because he never caused the animal to fall in. It might have been that it died in his pit. But we say if the animal was intelligent and mature, there would be exemption and no liability for damage if an intelligent, mature animal fell in a pit. So in that case, according to the rabbis, there's no collection by the owner of the pit. So in our Mishnah, when it turns around and says the owner of the pit pays, we're saying the owner of the pit pays for one simple reason, is that we hold by Rabbi Nassan, who said both parties that contributed to the death pay, and since we cannot collect from the digger, since he indirectly made the animal fall in by giving it a fright from the noise of his digging, and he never pushed the animal in directly, we then have to collect the money from the owner of the pit, including the digger's share, the shortfall. So Rabbi Nassan has taught us two unique principles, and that is, if you cannot collect from the one partner or the primary damager, you can then collect from the secondary damager. In other words, the shortfall. Okay, so we learn, number one, that there can be more than one damager that is involved in liability. And number two, if you cannot collect from the one damager, you can collect from the secondary damager. So same thing, if you cannot collect from the owner of the pit, you collect from the one who pushed him in. Either way, it's jointly and severably liable, okay, which means you can either collect from them together or the one has to pick up the shortfall of the other. Now, Gavin Austin brought up an interesting point yesterday, and I said there are two rabbinic opinions. The one is that if somebody doesn't have money or absconds, the one rabbinic opinion, when we say rabbinic, we mean like Tanoim and great people, not people like in our later generations, is saying that you can collect if the one party defaults in terms of payment because he doesn't have money or he absconds, and the other partner picks up the shortfall. And the other opinions in the Gemara have turned around and said you can't do that. Only when there's a Torah exemption enabling you not to collect from one party. So, for example, if the ox is tam and you can't collect full damages, the ox that pushed another ox in is tam, you can't collect full damages from the one person, you collect the balance from the other person. In that case, there's a legitimate Torah exemption or leniency in terms of the amount of payment. But if the person absconds or doesn't have money, you cannot expect the other person, if that person by all intents and purposes should pay, the other partner to pick up the shortfall in that case. So those are the two rabbinic opinions. Have I made these issues clear? Just put a thumbs up, Arthur, or something that you've heard. Okay, nod. Okay. Right. Okay, good. That's fine. That's perfect. So, Kevin, am I making sense to you? Gavin, am I making sense to you? Am I making sense to anybody?
Yeah, Damon, just another thing. I just wanted to, what happens if the owner of the pit commissioned the digger to dig? Okay. Surely the digger is not liable on any count.
No, he is.
Maybe the owner.
He is. The reason being, it's an excellent point. It's what Arthur was also confused about. Ein shaliach lidbar aveira. There can be no agency to commit an act of transgression. So if I hire you to do something illegal, okay, like create a hazard in the public domain, by you accepting the role for payment, whether you're a hitman and you kill somebody, in that which case that person that does the killing on behalf of the mafia boss gets the death penalty, or you create civil unrest, or you create a loss of money for somebody, as the person being paid to do something illegal, the responsibility rests with you as the agent, not with me, because you can't prove it's me. If you turn around and said, but Damon paid me, they're going to say to you, but didn't you know what Hashem asked of you? Didn't you know the law? You cannot say you did not know the law. That's not an excuse. So since you were caught directly, you have to pay in one way or another. And because mine is indirect, Ramah, I don't have to pay. Now, in Shemayim, the person paying you to do an illegal act is liable. But in an earthly court, only the person doing the act is liable. Because you're not allowed to do what Hashem does not want you to do. So therefore, as the digger, I hired you to create a hole in the public domain. You're not allowed to create a hole in the public domain. Therefore, when you create that damage, the court holds you liable. In that case, you're not liable only because you gave the animal a fright. But if they saw you push the animal in or hit it with a spade, you're liable. Or if you dug enough that you made it a lethal pit and then the animal fell in, you're liable. But not in this case. Am I making sense? I feel like I'm in a 1920 silent movie.
To me, I was wanting to see Kevin. Kevin, are you cutting it?
Okay, so the owner of the pit asked the digger to extend the width or to dig deeper, and
Either way, yeah.
so that facilitated the death of the ox that fell into such over 10 tefachim is a lethal death.
I'm asking you as follows. Rav Shimi Bar Ashi is telling you that the Mishnah goes according to Rabbi Nassan. The reason I'm asking you why. What does the Mishnah say that makes you know it's going according to Rav Shimi Bar, Rav Nassan, according to Rav Shimi Bar Asi?
The Rav Nassan say there's liability regardless if the ox falls frontwards or backwards.
No.
Didn't he say that?
No. That was Shmuel. That was Shmuel. So let me just.
I don't remember all the opinions.
No. It's not the opinions. What I just.
Not because you have done prep. Are you quite tired?
I am a bit. Yeah, I worked till 1:30 this morning, but no, I'm fine. I'm
okay. So
I don't.
So what we're saying is that basically the reason why Rav Shimi Bar Ashi is saying that it's the opinion of Rav Nasi is it says the master said if the animal fell forward because of the sound of the digging, the owner of the pit is liable. But why is he liable? So what we're saying is, why is the owner of the pit liable? That's what we in fact saying. That's indeed the entire question. That's what we can't understand. Because if you're holding according to the rabbis, the owner of the pit has nothing to do with it. He never caused the animal to fall in. It was the digger. Correct. So that's why when the master, the Tana of the Mishnah, is turning around and saying that the owner of the pit is liable for what the digger caused, you could say, well, it's odd because the digger himself, even if he's paid by the owner of the pit, has to assume responsibility for his wrongdoing. He can't say, I got paid to do it. You can't get paid to do something illegal. You have to take responsibility because you were the one that did it. So there's no indirect payment that the pit owner should make if he paid the other one. Unless you're holding by Rabbi Nassan, who said both parties that contribute to the death are liable. And who are the two parties? Well, where was the dead animal found, Kevin? Let me put it like that.
In the pit.
Correct. So Rav Nassan said the dead animal was found in your pit. Well, as the pit owner, you pay. And the digger, had he hit the animal with the spade or the animal fell in because he dug enough of the hole to make it from a injury-based hole of 9 tefach to 10 tefach, he would be liable as a co-contributor to the death. Okay? Or if he pushed the animal in directly or hit it with a spade, he'd be liable. Why is the digger not liable? Because he gave the animal a fright and the animal fell in. So it is an indirect cause of death. So therefore, since we cannot collect from the digger, we collect from the owner of the pit. And Rabbi Nassan also teaches us that other principle that if you can't collect from the one co-damager, you collect from the other, jointly and severably liable. So let me go through the Mishnah, the Gemara a little bit and cover a little bit of ground. And if I cover a bit of ground, we can always come back to the finer points. I think let's just move on. Okay. So Rav Shimei Bar Ashi said, whose opinion is this ruling? It's the opinion of Rav Nassan, who says that even when an animal is made to fall by another party, the owner of the pit did the damage. In other words, the fallen animal was found dead in his pit, so he bears the ultimate responsibility. That's what it says in the Gemara. Don't read the word, guys, ultimate responsibility. Read the word also responsible, meaning they're both responsible. Okay? And wherever it's impossible to collect from the damaged party to recover his damages from this one, he recovers it from that one. In other words, there are two parties who damaged him jointly, and if you cannot collect from the one party, you then collect from the other. In our case, since the damaged party is unable to collect from the digger, because it indirectly gave the animal a fright, they didn't push the animal in, he recovers the entire amount of his damages from the owner of the pit. Okay? So, the Gemara demonstrates this from Rabbi Nassan's opinion, because it was taught in a brisa, if an ox pushed its fellow into a pit and it died, the owner of the ox that pushed is liable, but whereas the owner of the pit is exempt. Now, I just want to fix something here that's in Schottenstein, because when it says in Schottenstein it's trying to demonstrate Rav Nassan's liable, it's now just saying something opposite to Rav Nassan. So I want you to understand that the brisa that it's bringing forward in that next sentence, sometimes I don't like the way Schottenstein is laid out, is actually giving the opinions of the rabbis. Because it was taught in the brisa, if an ox pushed its fellow ox into a pit, so you've got an ox and it pushed another ox into the pit. This has nothing to do with the digger now, Kevin. It's the classic case of Rav Nassan, and it died. The owner of the ox that pushed is liable, whereas the owner of the pit is exempt. So whose opinion is that? That is the opinion of the Bava Kamma, which is the opinion of the rabbis, who say, listen, ox A pushed ox B into the pit. Ox A is liable because he's the primary damager. The owner of the pit is not liable. That is in disagreement with Rav Nassan. That's the classic rabbinical source of the majority of opinions. Okay? So this Tana that wrote the brisa disagrees with Rav Nassan, and he holds that liability rests fully upon the one who initiated the damage by causing the fall. So therefore, the owner of the ox is exclusively liable. Okay? Now, this case in the brisa is different to our Mishnah. Why? Because the ox pushed the other ox into the pit. And pushing is a direct act of damage. It's not a causative act. It's not like giving an animal a fright. So the owner of the ox doesn't enjoy the exemption granted the digger in our Mishnah's case, because in our Mishnah's case, it was an indirect cause of damage. Digger didn't push the animal in the pit. So according to this Tana, the Mishnah's case, both the digger and the owner of the boar are exempt. Okay, in our Mishnah. The digger because his act was indirect, and the owner of the pit because the other party initiated the damage. That's according to the rabbinical opinion, but that's not Rav Nassan's opinion. So I just want to correct the way it's laid out in Schottenstein. God forbid I'm correcting Schottenstein. I'm not trying to do that. But if you've seen how it's worked in print with Schottenstein, it's not always clear. It seems to indicate the opposite. So you've got to read it a few times to infer what I'm saying. Does that make sense? So Rav Nassan says something different. He says the owner of the ox that pushed pays half the amount of the damage, and the owner of the pit pays the other half the amount of the damage. Why? Because Rav Nassan maintains that since the violent ox and the pit actually joined forces to commit the damage, their owners share liability. So the owner of the pit must pay half, even if the damaged ox is an intelligent one. He can't claim, like he can normally claim, that the ox should have walked more carefully, as we learned from 54b, right? Why? Because the ox that got pushed into the pit was unable to avoid being pushed. So therefore, there wouldn't have been any sort of negligence if the possibility didn't exist that he fell in the pit. So therefore, the owner of the ox pushed him in the pit, but if there was no hazard, then there would be no death either. So that's why we make both parties liable, Kevin. That's exactly why both parties are liable. Does that make sense? Now, if you have a normal intelligent ox, we learned for the first time in this Mishnah, there's an exemption. If it's mature, meaning experienced, and of average intelligence of the ox, in other words, no brain defect, you exempt. But if the animal is young or retarded, special needs, or neurologically not sound, you're liable because your hazard caused it. But we say you can't use that excuse here as the owner of the pit because another ox pushed that ox into your pit. So why are you liable? Because if you never had a pit, the animal wouldn't have died. And yes, you don't have to pay full because the ox that pushed the other ox in, the owner of that attacking ox has to pay half too. So you both pay half of the damage. That's according to Rav Nassan. Okay, so that makes sense. But we can see that according to Rav Nassan, the owner of the pit is partly responsible, even when the animal is made to fall in by another party. Okay, so the Gemara now proceeds to prove that Rav Nassan also holds that when it's impossible for the damaged party to collect from one of the damages, he recovers everything from the other. So the proof emerges from a contrast between Rav Nassan's ruling in the previous brisa and his ruling elsewhere. Because it was taught in another brisa, Rav Nassan says the owner of the pit pays 3/4 of the damage, and the owner of the ox that pushes the other ox to its death pays only 1/4. So we want to know, Kevin, how do you reconcile the brisa? What are you talking about? Because the other brisa seems to imply that they go halvies. The owner of the ox that pushed in pays half, and the owner of the pit pays half. Now we're saying that the owner of the pit pays 3/4, and we want to know how that can be a contradiction. Why is he paying 3/4? So we're saying, listen, there's no problem reconciling the brises. Why? Because this latter brisa, the last one we dealt with, deals with a case where the damaging ox is a tum. Okay? Whereas the former brisa we learned deals with the case where it's a muad. So when the damaging ox is a tum, its owner pays only 1/4 of the damage, and the owner of the pit pays 3/4 of the damage. But when it's muad, its owner pays half, and the owner of the pit pays half. Okay? So it's explained like this. Okay? I've caused 200 zuz worth of damage. There's 200 zuz worth of dead ox lying at the bottom. My ox pushed it in. I owe 100 zuz because it's muad. It's a habitually goring ox. And as the owner of the pit, you owe the other 100 zuz. That makes sense, right? Because I would only owe half the money. But what we're saying is that my ox was was a tame animal relatively, so it hadn't habitually done damage, and therefore it only owes half of what it owes. So therefore it owes half now because I share the liability with the owner of the pit. So instead of paying the 200 zuz, I pay 100 because if it was muad, I'd owe 100, and the owner of the pit would owe 100. So now we share liability because we both contributed to the animal's death. I then reduce my liability by a further 50% of what I owe. So 50% of what I owe, if it was muad, I now owe 50% of that if it's tam, which means I actually only owe 25%, which means, according to Rabbi Nassan's second rule, is the owner of the pit has to pick up the shortfall. Why does the owner of the pit have to pick up the shortfall? Well, if my ox was lying dead at the bottom, I'd turn around to the owner of the pit and say, well, guess what, pal? I found my ox at the bottom of your pit. What I can't collect from this guy, I'm collecting from you. And according to Rav Nassan, I would collect 3/4 damages from the owner of the pit because it was a tam ox that pushed it in, and a quarter from the attacking ox. But do you understand how we derived it a quarter?
Because it's tam.
Because it's tam. In other words, if my ox did the full damage, there was no pit. It gored it to death, just gored it to death, like this, with its horns, dead. Then fine, I owe 200 zuz if it's muad. If it's tam, I owe 100 zuz. But if it gored it and knocked it into the pit, and the pit also contributed to its death, and it's muad, there's 200 zuz of damage, I owe 100 if my ox is muad, and the pit owner owes 100, so we both repaying the owner of the dead ox is 200 zuz. Now it's tam. So the 100 I owe is halved, it's now 50 zuz, and then the owner of the pit has to make up the shortfall of that extra 25%, because if the owner of the dead animal comes to the guy of the pit, he says, listen, I'll recover everything I can from that guy, but what shortfall from him, because it was tam, I'm collecting from you because my animal was dead in your pit. So I just want to know, Kevin, you understand that principle before the Gemara has any questions. Okay. So now that's the case. The Gemara still continues struggling to understand Rav Nassan's ruling, being a tam. Why? Because it says, and regarding the case of a tam itself, what does Rav Nassan hold? In other words, on what basis does he impose 3/4 of the payment on the pit's owner and only 1/4 on the ox owner? Okay? Because if he holds that this one, the ox did the entire damage, and this one, the pit also did the entire damage, okay, then this one, the owner of the ox should pay half, and that one, the owner of the pit shall pay half, okay? And if he holds that this one, the ox did half the damage, and that one, the pit did half the damage, then the owner of the pit should pay only half, and the owner of the damaging pit should pay 1/4, and in other words, then the damaged party should lose the other 1/4. Does that make sense? So there's two ways to hold, Kevin. The one way is saying, all right, we understand that it's tam and that you can't recover that extra half of the half from the owner of the attacking ox. But why should you collect it from the owner of the pit? It's not his fault. He's paying his share of half. Why should you collect an extra 1/4 from the owner of the pit? That's the question. Or do we say that you do? And I'm going to discuss this point now. Just give me 1 second, guys. I'm just pausing the recording. So, cool. So, Kevin, look, there's two ways to work it out. Let me tell you what the implication is. So, inherently, this is the case, right? The Gemara is considering two ways of defining the partnership, right, in terms of liability between the owner of the ox and the pit. So we can view each damager as being responsible for the entire damage, with the payment shared because there's no need to compensate the damaged party twice for one loss. Okay, that's according to the Chazon Ish. Or alternatively, we can say that each one is inherently responsible for only half the damage. In other words, each side of the issue will, in other words, it doesn't have any bearing of the case where it's muad, only where it's tam. Because if it's muad, they still pay equal amounts. The only question is when it's tam. When it's muad, we say whether they are liable in their entirety each or partially each, it doesn't matter. If my ox is muad, I pay half, the pit owner pays half. The argument only comes when it's tam. So what's this concept of entirety or partiality in terms of partnership? Can Gavin or Arthur give me an answer?
So what's this? Just repeat that last comment again, sorry.
When I say that each one in the entirety is liable as opposed to partially liable, what am I talking about here? And why does that have a financial implication? Either Arthur, because he's done Gemara with Rabbi Cohen, can answer that, or Gavin can.
So I can't remember this really. I've gone blank on this.
Damon?
Yeah.
And then Gavin, do you want to try? Maybe I'll try.
Sure.
So
I'm
you're
happy
saying
to try.
it's like why are they both fully responsible?
Okay, so there's two concepts here, okay? If it's muad, it doesn't matter which way you slice it. Each one pays half. The question of if it's tam. So it boils down to a conceptual issue of, is each one entirely liable for the damage on its own, but we don't pay the damaged party twice? In other words, in and of itself, the attacking ox should pay full payment, and the owner of the pit shall pay full payment. But this guy doesn't get 400 zuz for his 200 zuz dead ox. He doesn't get paid double. So it actually takes relief of each of the partners because they're both contributors to the damage. So we say, listen, each one in respect of themselves has caused the damage entirely, but since they're both parties, it provides a bit of relief because you don't double pay 200 zuz each, 200 zuz, because you've got a partner. So therefore you pay 100 zuz each and it's off the hook. Or do we say that they're partially liable as partners, and therefore that's why they pay half?
Okay, another answer.
I'm listening, Arthur.
Okay. So basically,
Art, we're battling to hear you, Mati. Just reshet.
If I'm 50, so off the what's the name, and I'll put it on. Okay.
Sorry, mate.
Well, okay, you're not speaking now, so I'm in the public group. Okay. Well, what I could say to him is, if I had attacked you, if this had happened to me and your bull was tam, I would only pay 50%, not 100. Okay. So therefore, because it's partial, I'm only responsible for 25 of it. Another guy's responsible for 25.
Okay. That issue, it's not at play now. I know what you're getting at. It's not at play now. I'll tell you what the issue is, and I'm pleased you clarified that with me. Let me just explain to you what this concept is: entirely liable, each and every party to their own, as well as partially liable. Gavin, do you have an answer before I give it?
No, I think it's Mark. I heard you correctly. I couldn't hear you properly. So I think so when you fully liable, it means that this is Rabbi Nathan. He's saying that you're fully liable. He's fully liable. So you've got the ox that hit the other ox, the damager. So he's fully liable, and the other one is fully liable, but they can't be double paid, right? Otherwise, like you say, they're going to get 200 each. So then that's when the partial, I think, comes into effect.
Okay, listen, I'm pleased you got the concept, but you're not understanding or communicating why. So this is what I just wanted to clarify, but at least you understand it. I'm happy about that. So what we're saying, Arthur, is as follows, right? Is like the Gemara understands the brises, meaning that the victim was rammed so forcefully into the pit, it wasn't nudged in. So the victim could have died even if there'd been no pit there, through being struck and thrown to the ground with this degree of force. Does that make sense?
Yeah.
Arthur? I wonder if Arthur can hear me.
It didn't have to be in the pits because of the sheer force could have caused.
Arthur, mate, can you hear me? I just want to know if you can hear me. It's important that. Oh.
He's got a very bad reception there.
All right, just give him a second. I don't want him to miss this. I'm sorry, guys. I'm doing my best. How's it, mate?
Sorry, the connection here is bad.
Okay, no problem. Can you hear me now? Relatively. Okay. Can you hear me?
I can hear you. Yes.
Oh, that's fine, as long as you can hear me. So what I'm saying is as follows. When we say that each person is liable in the entirety, we're saying we don't need the other damager to make them fully culpable. And that has a financial impact. So what I'm saying is the attacking ox hit this other ox with such a force that even if it didn't drop in the pit, it would have died on impact. It was rammed like that with horns. Bang. It could have died on flat ground. That's how forcefully it was rammed. Therefore, the attacking ox hit it with such force, you didn't need the pit to make it fully liable. Okay, so that's that first concept. then the second concept of fully liable is had the owner of the pit dug a pit that was 10 tefachim deep. You didn't need another ox to push it in. If it fell in, it would have died anyway, or at least been legally responsible for the death. So therefore, it's fully and entirely liable in and of itself, the owner of the pit, for creating a lethal pit. It's not like it's a 9 tefach pit. It's a 10 tefach pit. It didn't even need the other ox to knock it in. And that's why we're saying each one is entirely liable on their own. They're not contributors. Contributors implies that you needed the force of both to create a lethal force. But since each one of them on their own could have created that degree of lethal force, we technically, on that basis, would hold that sort of entirety liability. And that's where the 3/4 comes in. Because if we say they're partially liable as partners, okay, if you're holding by that argument, then there's no reason why the owner of the pit should pick up the shortfall. Yes, he should pay half, but no more than half. Why is he more liable than half? Because he should pay the whole thing. His pit is 10 tefach deep. It could have died without the other ox's impact. And therefore is entitled to pick up the shortfall. And if the owner of the pit, let's say the owner of the pit absconds, according to those opinions that says for absconsion or a lack of funding, you make the other party pay, not where there's an exemption or whatever the case may be. Let's hold it according to that opinion. Then guess what? The owner of the ox that pushed it in would have to pay in full. Why? The shortfall of the pit owner. Because he hit the ox hit the other ox with such a lethal force, it didn't need the pit to cause death. So therefore it would be fully liable. The reason why it would only be liable for half in the case of Tam and not the shortfall is because it would never pay more than half. So if it would pay a quarter, it would now pay a half. That's what happens when you make each one in entirety liable. Does that make sense? As opposed to partnership jointly. In other words, each one is partially liable because their combined forces then contribute to the death. It's not each one on its own capable of causing the death. So it depends how you look at it. Does that make sense? So the concept that each one did the entire damage would explain how Rav Nassan can impose more than half of the payment on the owner of the pit, if for whatever reason his partner pays less than half. But it still leaves us as a loss to understand why the owner of the ox should actually pay less than half. Because a tam always pays for half of the damage that it did. This is the question in the Gemara. And since we view the ox as having done the entire damage, in fact, it should be liable for half. So Rashi is saying that since the owner of the ox hit the other ox with such a force to have caused half the damage, and you don't compensate the damaged party twice, each of the partner deflects the responsibility from half the act to his fellow. So in other words, the tam is not entitled to a further discount because the law of tam states that it pays for half the damage that it did, not half of what the muad would have paid. So the amount he must pay under the law of tam precisely equals his liability under the terms of the partnership. There's no basis for combining both those factors to let him pay 1/4 because the Torah doesn't grant a tam any dispensation beyond the half damage threshold. Okay, so do you understand the argument at play? So I'm saying if you want to say there's an entirety of damage and your ox, and you should owe the 200 zuz, and your ox was tam, well, then you're paying 100 zuz because the owner of the pit owes 100. But even if he was not in the picture, you still owe 100, which is half of 200. That's enough of a dispensation. Why should you pay a quarter? That's the other side of the argument. That's what they're grappling with. It doesn't, in other words, you don't get a further dispensation by having the tam and a further discount of a quarter. Neither does the other party have to pick up the quarter. So that's what we're arguing about. So let me just finish. We've got about 6 minutes, and then I'm going to make it very, very clear. We're almost done. Don't worry. Okay. So the Gemara answers. So in other words, does the owner of the pit compensate for the 1/4, or does the owner of the dead ox have to take a dive for the quarter? Does that make sense? Or do we make the owner of the tam ox still pay half? Because he should be paying full if you're seeing him as the entire damager and the owner of the pit is the entire damager. So Rava said, Rav Nassan is a judge. Not only was he a judge, guys, I don't know if you know this, but he was head of the Sanhedrin. He was chief Beis Din of the great Sanhedrin, of Beis Din. That's a big thing. Okay, that's not according to Rav's opinion. That's in Horayos, the 13th daf. That's by all opinions. That's how big Rav Nassan was. And he fathoms the depths of the reasoning behind the law. So actually, Rav Nassan holds that this one, the ox did the entire damage, and that one, the pit, also did the entire damage. And as for your question, let this one pay half and that one pay half, Rav Nassan reasons that this is not justified because the owner of the damaging ox, okay? In other words, the owner of the attacking ox can tell the owner of the pit, if I must pay for half the damage, what did my partnership with you accomplish for me? Since my ox was tam anyway, I would have paid half even if I did the damage by myself. Therefore, the partnership with you must render some sort of benefit from me to reduce my liability to 1/4. And the remaining 1/4 must instead be paid by the owner of the pit, since he is viewed as having his entire damage done also on his own. He's obligated to pay whatever his partner leaves. Okay? So what we're saying here is that according to Rashi, Rava innovates that the partnership actually allows each damager to deflect to his fellow not merely the responsibility for half of the act, but half of the payment that would have been imposed on him if he did the damage by himself. So since if the tam had acted independently, he would have only had to have paid half anyway, guys. So what was the point of the partnership? The partnership is there to reduce his liability any further to 1/4. Otherwise, there's no benefit to him by having a partner that also contributed to the debt. So you might wonder why was the share of the tam reduced by 50% to 1/4, whereas the share of the boar is reduced only by 25%. In other words, from full payment, he has to pay 3/4 of the damage because he's picking up the shortfall. So he only gets a 25% discount. So the answer is that since the tam would have at most, guys, had to have paid only half, and he's the owner, his partnership with the owner of the pit, with respect to only half the payment, there is a partner in the entire act. The owner of the pit bears sole responsibility for 1/2 of the payment, and therefore the partnership allows him to divide only the other half of the ox. So that results in the 75-25% distribution. Because what can be the other argument? So we're saying the one side of the argument of Rav Nassan, we've got 2 minutes left, is saying that the partner of the attacking ox says, listen, your partnership had to have given me something. I only had to pay at most half anyway. So there's another way to view it quickly. If you prefer to say that actually Rav Nassan holds that the owner of the ox did half the damage and the owner of the pit did half the damage, let the owner of the pit pay half and the owner of the damaging ox pay 1/4 and let the damaged party lose the other 1/4. So how would Rav Nassan answer that? He said, listen, it's reasons not justified because the owner of the damaged ox, the dead ox, can tell the owner of the pit, I found my dead ox in your pit. You killed it. Therefore, whatever I can recover from the owner of the ox that pushed it in, I will. But the rest, you owe me. It was in your pit, I found it. So since the owner of the damaging ox only pays 1/4, you must pay the remaining 3/4. So we can see that Rav Nassan maintains whatever his partner leaves unpaid, the owner of the pit must pay the shortfall. Does that make sense, guys? Okay. So therefore we can understand our Mishnah to say, like, look, where the digger did an indirect act by giving the animal a fright, he doesn't have to pay anything. So then who does the shortfall of the payment go to? Well, then the owner of the pit, as a partner, has to pick up the payment because there's an exemption for the digger of the pit, A, because he didn't dig enough to make liability, but it doesn't even need that because he just gave the animal a fright from the sound of the digging. That's all. So therefore he's exempt completely. So according to the rabbis, your primary damager would pay, the digger of the pit wouldn't pay because it's indirect. You wouldn't collect from the pit. According to Rav Nassan, the owner of the pit would have to pick up the shortfall. So that's in essence what we're dealing with, guys. That's the bottom line. Okay, I hope I've made it clear.
That's pretty good. And Rabbi Nassan really, he really makes a lot of sense. I like his point.
I like him a lot. Arthur, did I clear it up a little bit for you?
A little bit.
Okay. You're still confused. I think you sleep